Okay, so I'd like to introduce our speakers today. We're going to be talking about how we're dealing with estate planning and the COVID-19 virus. So today we have with us Jill Beyer. Jill is the chair of the Trust and Estate section for the Bar Association. We have Tara Pleat. She is the chair of the Elder Law and Special Needs section for the State Bar. And we have Deb Kearns, who is the chief clerk for the Albany County Surrogates Court. We understand that everyone is really concerned about how our practices are being affected by the virus. And this group has decided that we would like to have a little discussion to hopefully maybe put some fears to rest and help our section with deciding how to go forward. What we need to remember is that this is a discussion only. Every attorney needs to use his or her best judgment when making decisions with respect to his or her clients, and that we're here to help and we're here to try and give you our ideas. But again, you are your own best advocate, and you should make sure that you're using your best judgment when dealing with your clients. So Jill, I'd like to start with you. Could you please provide us with a brief explanation of the task force for the Bar Association and their efforts in relation to our estate planning practices and the COVID-19 virus?
Okay, so I'll just back up and say and start with a committee that we formed maybe about a year ago, an ad hoc committee to look at electronic wills and digital wills. At that point, there were 3 states that had enacted electronic will statutes. Florida came on board. That was Arizona, Indiana, and Nevada. Florida came on board shortly thereafter. And the Uniform Law Commission was also developing a uniform law related to electronic wills. So we felt it was important to form an ad hoc committee to look at these statutes and figure out if this is something that the state of New York wanted to pursue, and if so, in what form. These statutes are very complex, and there's a lot of complexity involved in these statutes. So from that, when all of this happened, we had this committee that had already done some work dealing with witnessing happening remotely and that sort of thing. So I took that group, added some members of the Surrogates Court Committee, Deb Kearns was one of them, and some members from our legislative committee to put together some in the immediate need, putting together some information to help practitioners just think about how to deal with clients that possibly were in an institution and unable to get out and nobody was able to get in, how to deal with those kinds of situations. So we did that pretty quickly, and then since then we've been looking at whether emergency legislation, what type of emergency legislation would be appropriate to deal with this as this continues to drag on. So that's essentially what we're doing. We're still in the middle of that work, our process at the State Bar is not simple. Once the committee comes up with something, we have to go through the executive committee of our section, and then it has to go through the executive committee of the New York State Bar Association, and then from then to the legislature. And to be honest, right now the legislature is dealing with other pressing matters. So we are still working on it, but it will take some time before we can get something done, even on an emergency basis.
Thanks. One of the things that happened with Governor Cuomo is that we have an executive order for remote notary. Tara, could you please explain how the new remote notarial under Executive Order 202.7 works?
Sure. So that order was issued on March 19th of 2020. And I guess just one of the comments about the executive orders in general is they're good for 30 days. And so this particular provision is only good through April 18th of 2020. And it may be extended depending upon what happens with the overall states of emergency in New York. And it is specific to notaries only, which I think most members of our sections know from the various postings that have gone out over our listservs, as well as information that's been put out by the Bar Association. So only is applicable to documents where the only type of signature that's required is one that is notarized. Basically, there's a handful of steps that have to be taken in order for it to be done properly under the executive order. The first is that during the video conference, so this is contemplating video conference notarization, but during the video conference, the person seeking the notary's services has to present a valid ID to the notary during the conference, unless that person is personally known to the notary. So Trish, if I didn't know you and this was a conference, a video conference where I was serving as a remote notary for you, I would be asking you to hold up your driver's license, and I'd also likely take a screenshot of it so I could show that I received it. It was transmitted during the video conference. And as I said, it has to be provided and transmitted during the conference, not before or after. So that's step number one. The video conference, much like this one, has to allow for direct interaction between the notary and the person signing the document, which means we can't have a pre-recorded video. Rather, the notary has to be able to communicate directly with the person who's signing the document. And I think just as a matter of information, it can be accomplished through a number of different services like this one, Zoom, there's Google Hangouts, there's FaceTime, there's GoToMeeting videos, there's Zoho videos, there are a bunch of other video conferencing alternatives, but it has to allow for the give and take that's occurring like in this call. The person that is signing the document, so again, Trish, if it's you signing the document, you have to affirmatively represent to me that you are in the state of New York. So it's a question I would likely be asking you, and then asking you what county you are situated in New York State for the purposes of the notary. And then you can sign on video, and I can watch you do that. And then you have to transmit to me by fax or other electronic means a legible copy of the entire document that was signed on the same day you signed it. So it's not going to work if you have to wait until tomorrow to get someplace where you can scan it in and email it to me. It's something that you have to be able to electronically provide same day. That can be, and this is a challenge for some of our senior clients, obviously, but that could be something as mundane as I can take a picture of each page of the document and text it, or use it through a phone to email. We have the concerns as practitioners of not wanting to give our private cell phone numbers out to the majority of our clients, but we have to figure out ways to make that work. Once that transmission has occurred, once I've received the electronic version of the document, I'm allowed to stamp that document and sign it as a notary. There's some question that has come up over the course of the last couple of weeks on the listserv as to what's the appropriate county. If Trish, you're in Albany and I'm in Saratoga. In our practice, we're taking the position that we as the notary are where you are in New York State, because you are the one that needs to identify where you are. So when I notarize your signature, I'm going to say I'm sitting in Albany County with you. There are differing opinions about that. And again, the point of this video conference as a whole is to give everybody the sense of what some of us are doing, but you ultimately all have to make your own decisions and judgment calls based on what you know the rules to be. Very last step is that once that's done, I can retransmit the document to Trish that has my notarization stamp on it, and then Trish can mail me the original with her original signature, and upon my receipt of that, I can stamp the original, sign the original, and it would be as of the date I watched it happen through the video conference.
Thank you. So while that works for notaries and for things that need to be notarized, like a power of attorney or a deed or other things that only require the notary, that's not going to work for us for purposes of executing a will. So before we get on to how we're going to potentially address signing wills remotely, Deb, could you please provide us with an explanation of the will execution requirements under EPTL 3-2.1, specifically as it relates to the phrases within the statute of in the presence of and the 30-day acknowledgement requirement.
Sure. So under 3-2.1 A2, the signatures of the testator shall be affixed to the will in the presence of each of the attesting witnesses, or shall be acknowledged by the testator to each of them to have been affixed by him or by his direction. So the testator can either sign in the presence of the witness or acknowledge his or her signature to each of the witnesses. So it doesn't have to be done in the presence of each of the witnesses, and you can use a combination of both. So the testator can sign in the presence of one witness, and then the testator can then acknowledge his or her signature to the witness later on. And then under 4, there shall be at least 2 attesting witnesses who shall within one 30-day period both attest the testator's signature as affixed or acknowledged in their presence. So it has to be done within a 30-day period. So there are ways in which the statute provides for not having everybody in the room right now at the same time. It's not as easy as, you know, it's not, New York is a strict compliance state, right? So that's what we're all worried about. We don't have those substantial compliance rules like many other jurisdictions. So these witness rules are what's causing us problems right now.
So Tara or Jill, any comments on Deb's explanation?
So I will say that what you guys are talking about, elderly clients who may not be technologically capable, I'm going to use that word, of scanning and dealing with just what we're doing today, a Zoom call or a Skype call or even FaceTime. I did speak with a practitioner who's trying to figure out how to get some documents signed for a client that was like that. And I suggested that the client had a particularly close relationship with their financial institution, goes there every day, they all know this person. Financial institutions are considered essential. And so what they ended up doing is that client went to the financial institution and the individuals there assisted that elderly client in dealing with the technological struggles of getting something signed, a power of attorney signed remotely. So that's one option, if that might work. You could go to an essential business and someone there may be able to help that elderly client.
I think the only thing I would add to that is that they're, again, understanding that all of us are on the various listservs of our sections. There's been a lot of questions being asked, a lot of proposals that people are putting forth as it relates to the situations that have come up where people are already undertaking remote witnessing of wills, of advance directives, even of the gifts rider on the power of attorney. And while it would be wonderful to have, even if it were only a temporary fix, come out of the legislature or the executive, we really have no idea if that's going to happen or not. It is happening in other states. There have been emergency either statutes or other executive orders that are addressing effectively the definition of in the presence of, and confirming that in any statute where that language is applicable, it can mean in the presence by video conferencing. That would be a lovely fix for us to deal with right now, and there have been efforts made in that regard, but you know, we don't know what will come of it, if anything. We all think, I think it's a good idea for the 5 minutes we're going to need it, the very short period of time in which we expect to still be on pause. But as a number of practitioners have voiced, it creates a host of problems later on down the road. So we're just trying to do the best we can with what we have here. And this will come up probably later, but for some of us, I think what we're doing is exactly that, the best we can, with the expectation and hope that when we come out on the other side of this, anything that we have executed not in strict compliance with what we believe the applicable laws say, we're hopeful we're going to have the opportunity to re-execute when we're on the other side of the New York pause. And by the same token, there may very well be that we have some sort of either retroactive legislation that deals specifically with this period of time, or perhaps some practical application or practical review of the circumstances by the surrogates if any of these documents end up being placed before them for probate or otherwise.
So we've talked about executing the documents remotely. Do you have concerns with the security of video conferencing and client confidentiality, like using Skype or Zoom or any of the other services around?
I just recently heard that there's some issues with people just jumping on Zoom calls without authorization, and it's sort of wide open right now. If you've got a link to a Zoom call, anyone can jump on, and if they're not using their video, you may or may not know that someone's on the call. So yes, it's a concern. It's even a concern emailing documents if there's not an ability to send them through some sort of secure method. So I think all of these things certainly need to be addressed, or they could become problems down the road.
Okay, so CNBC reported this past weekend that many people are turning to online services to prepare their wills or their other estate planning documents without the use of a lawyer or engaging an attorney. What are the risks of the do-it-yourself estate plan? So I'll ask Jill from the Trust and Estates perspective, Tara from the Elder Law and Special Needs perspective, and then Deb from the probate perspective. So Jill, what are your thoughts?
So I'm not sure that my thoughts are different in this environment as they would be in a regular environment about someone going to Zoom to do a will without a lawyer. I think it's there are going to be some issues with individuals doing that. But because we're in a strict compliance state, I don't think even doing a document on Zoom is going to change the end result of needing witnesses and having to deal with how you're going to get that witnessing done. There was one case in Connecticut, which I think would the same result would happen in New York, but there's a case in Connecticut where an individual went online, created a Zoom account, created a will. The will, LegalZoom sends the will to be signed. That happened. The individual got sick and was unable to sign, and the survivors attempted to say that because the individual had opened an account and actually done a will, even though it was never signed, that it was actually a will. They could use that and probate. The unsigned copy in Connecticut said no. The same result would happen in New York. So I'm not sure that it's a whole lot different in this environment. It's fraught with problems.
Tara?
I think to add on to what Jill said just about not being able to properly execute it, obviously, in relation to wills, if you've ever seen those LegalZoom documents, even though they, I think they indicate that they are state specific, they're not. They lack appropriate provisions as it relates to general bequests, residuary, pre-residuary. There's a host of problems with them that can create construction issues later on. So that's number one. From my perspective, though, I think where we get concerned about those types of online tools, in addition to things like it is likely not going to be done right when it comes down to a will. From the elder and special needs law side of things, I'd probably focus more on the durable powers of attorney that are there and the modification sections that exist and the need for a comprehensive statutory gifts rider, the need to make sure things are initialed as opposed to checked off or some other inappropriate way of executing the document. But often, and again, to echo what Jill said, this is an issue whether or not we're in New York State on pause. This is just a problem with those sorts of tools to begin with, is that a power of attorney document in particular, if it is done through that format, there are not questions being asked about what types of transactions are you contemplating. And you can see documents that are basically ineffective if you're dealing with somebody who's in an extreme healthcare situation and they need to deal with accessing assets or transitioning assets, and perhaps don't give the breadth of authority that you would anticipate seeing in a properly drafted or constructed power of attorney with a gifts rider. Just a lot of stuff gets missed, and typically people are getting what they pay for, right? You pay $100 online to have somebody prepare a will and a power of attorney for you. That's exactly what you're going to get, a $100 document.
So Deb, from the court's perspective, how do you deal with the documents that get presented to you that aren't prepared by the lawyer? They're done by the LegalZoom or some other service, and it's just not done correctly.
Well, to what Tara and Jill were talking about, we had these problems prior to this pandemic. So oftentimes, as Tara mentioned, they're not state specific. So they're not done with the proper will execution requirements under New York law. The attesting witness affidavits are either not there or they're incorrect. So it's very hard to probate those types of wills. They've been probated. We've probated those types, but it's really hard. And as Tara mentioned, sometimes they leave out clauses, and it leads to all sorts of construction issues. So, I mean, this doesn't present any sort of a different quagmire with respect to those types of services, but I can see it increasing based on the more frequent use of these right now. So I anticipate that we'll have a bigger problem down the line.
My guess is there's a false sense of security. I'll use that word of going to LegalZoom and saying, hey, I can get my documents done online without a lawyer right now.
The tough part is, how can our section members really fight that do-it-yourself mentality of how do we make sure that they understand that what they prepared using LegalZoom or whatever source they have, how do we fight it and say, you're not getting the service that you think you are, and when it's time to probate that will, it's not worth the paper that it's written on. And I don't think that's an answer for any of us, other than that's the same kind of thing that we have to fight on a regular basis. I had a client come in and argue with me, or a prospective client come in and argue with me and say, well, I'm good with what the laws of intestacy are. And my thought was, then why are you here? If you know the law and you're good with it, then why are you coming to me? And he was okay with the laws of intestacy, I suppose. So Tara, from the elder law perspective, what is happening with the clients who are currently residing in nursing homes and other facilities that are not allowing any visitors? Have you felt, or have you dealt with getting documents signed by people in those facilities?
So I have not personally done that since this New York on pause, and even prior to the New York on pause. I think at least in our neck of the woods, earlier in the month of February, our facilities, and I'm in the Capital District for anybody who doesn't know that, we all are actually. Jill's in the North Country, but we're all upstate girls on this call here. But the facilities in my neck of the woods had sort of closed off to visitors for the most part, unless there was an extreme circumstance happening with a particular resident or patient well before the beginning of March. And so in an effort to try to think proactively about exactly what we're seeing posts on our listservs about now, facilities, either in the business offices, nobody's answering the phone. There's a concern just generally with your client's children that they're not able to put eyes on their parent or on their loved one in a skilled nursing facility, which, as many folks know, the squeaky wheel gets the grease in a lot of these residential healthcare facilities. And so there's a need to be a proactive advocate, not just on the document side of things, but on the management of overall care and healthcare. You got to be on site and you got to be vocal to ensure that a level of care is being provided in the same way you would want it for yourself or your own parent. And there has been a great hampering to that at this point. In Saratoga County, I sit on the board of a skilled nursing facility, and I've actually been working with one of my colleagues there to come up with a way that, again, it's a, how do I say this? It's sort of a patchwork way of dealing with these issues, because to the points that we've already made, not really sure if it's actually going to be in compliance or accepted if these are documents that we have to deal with, because they can't be re-executed after the doors open back up to these facilities. But on that board, we have, I think, maybe 16 iPads that are there for board members when we come into board meetings. And they've recommissioned those and they've turned them into Skype calls, video conference calls, so that patients can see their families through video conferencing. And we've talked about how can we do this in a way that, again, there are nursing staff on site. So in many circumstances, facilities may have to relax their requirements that they don't allow their staff members to witness documents, or they don't allow someone in the business office to notarize a document. But I don't necessarily have to be one of the witnesses that's signing anything. I can watch it happen and ensure that it's being done the right way from a supervising execution standpoint. But you've got to, we've got to be able to give the facility sort of a step-by-step of what needs to happen and how it can be beneficial. The hard part is if it's somebody you don't know, right? And a child is calling and you're asked to make a capacity assessment. I don't know how comfortable I would be making a capacity assessment, not being able to be physically present with an individual. But there are real hurdles there. And really all we can do is reach out to the facilities. If we're fortunate enough to have contacts at those facilities, reach out, ask, is there somebody that can utilize their phone on FaceTime? Do they have iPads or tablets that can be recommissioned for the purpose of supervising a document execution? We know there's staff there. We know there's nurses there. We know there's aides there. They're essential. Are they willing to relax their rules if they have those rules that say they can't serve as witnesses? Is there somebody in the office that's a notary that could notarize the resident's signature? And really just trying to work together to allow for those things to happen. Not everybody, and again, depending on where you reside, they may or may not be willing or even capable because they're short-staffed to begin with. But we have to ask the questions, and for now, that seems to be the best way to do it. What I will say is once we sort of finalize what we're looking at with this facility in Saratoga, I expect to put it out for consumption on the listserv, not because I want anybody's feedback, because I know it's not perfect, and I know I will probably have to redo everything, but hopefully to give folks just some other options or thoughts about how they try to address it, if they're comfortable with that in their own circumstances, wherever they are in the state.
I would say, just to add on to that, Tara, you said something I think really important that I've thought, and I think a lot of people have been thinking, doing all of these procedures that are perhaps not what we would do in an ordinary environment. I would only do that for a client with whom I was already working and with whom I already knew. I don't think I would. I mean, maybe it will come up. I don't know. Never say never. But I'm not sure how comfortable I would feel utilizing some of these alternative methods for a client with whom I had never worked and who I did not know well. I have a client now whose primary home is in Long Island, and we're going to figure out a way to get documents signed. But I know this person, and I've been working with this person for a while. So I think doing something like that with a client that I'm not that familiar with, wouldn't give me pause.
And Jill, I don't think that really changes from whether you're in the facility or remotely, because would we ever really want to go and do a power of attorney for someone we haven't met and assess?
No, you're right.
So it's a tough call.
You're right.
So
I mean, it happens because, people all of a sudden have a need and they need to get a document signed, and, obviously it happens, but it's not ideal. And certainly under these circumstances, it's even less ideal.
Definitely. So Deb, we're talking about the emergency situations. How is your court currently dealing with filings and emergency proceedings?
Well, Albany County is an e-filing court, so we have the benefit of being able to see what's being e-filed, and We put out guidance to the Albany County Bar Association last week or actually March 17th, we did. We're going to issue new guidance in the next couple of days. The third JD issued an executive order, an order that said that the only real essential matter, the essential matters in surrogates court are urgent guardianships and adoptions, and other matters as determined by the surrogate in consultation with the chief administrative judge of our district. So we can handle emergency situations. So we can issue temporary letters. We can't have return dates right now because everything's been administratively adjourned and we're not in the courthouse. But we have access to the database and to the NICEF system from home. And we've established a system where we can issue letters in an emergency. So what we're asking people to do is they can file their proceedings on, they can e-file their proceedings and then send us an email and explain the situation, and we can get out temporary letters because we're getting a lot of requests for that, and we've already done it. There was a kind of a prohibition on e-filing in the very beginning, but that has softened. So for emergency matters, if people need access to funds, right, or in guardianships, they need access to guardianship funds, estates, estate funds. So there's people that need help with, housing, putting food on the table. People are losing their jobs, and, getting access to estate funds is becoming more and more imperative. So we can process those proceedings that are filed via NICEF. We are not presently, or we're not in the office physically right now. We've gone in a couple of times and to just kind of process what's there. But going forward, it's not clear how much we'll be physically in the office, but we're on email, we check it, we are on NICEF. So if anybody has a proceeding that they need to get processed, we can do it.
I think bottom line, you're Albany County, people probably, they need to talk to their own county because it varies county by county.
Oh, that's true.
Yeah.
Right, that's true.
Yeah.
Exactly. And many courts don't e-file. So if you don't e-file, that's a whole different set of circumstances.
Right.
Because those filings are not readily, accessible unless you're in the office, and then you're dealing with the mail. So yes, it's court by court, but Albany County is able to help in emergency situations with the matters.
That's wonderful news.
That's great.
So Jill and Tara, how has your practice changed, at least until social distancing is less than 6 feet, or when we can have, or when in-person meetings might be advisable again?
Jill, you want to start?
I think it's changed. Well, what we're doing right now is a function of what's changed, right? I will say though, because I'm in the North Country, and if those of you don't know what that means, I'm a long way away from Tara and Tricia and Deb. I actually meet with clients via Skype fairly frequently. So from that perspective, it hasn't really changed. Obviously, what's now changed is that I may have to do that. I may have to use that facility or Zoom, something like that, to actually get documents signed. I have not attempted to do remote witnessing. What I'm ramping up to do this week is I've got this client who is going to get witnesses where the client is, and I'm just going to supervise the will execution via Skype. And in my mind, that is, I think that's a fine way to get around some of these issues that we have. If it's an individual who's got in-laws that are able to come into the house, and the in-laws can be witnesses. They're not beneficiaries under the will. So mainly it's just in that in the signing of documents. But I have other clients that we were in the process of working on their documents, and we're moving forward and working on them as we would have in any other situation, emailing drafts, getting on a conference call or a Skype call to go through changes. And most people are okay with saying, we're just going to move forward and get it to a point where If we can sign them sometime in the near future, that's okay. But obviously, there are clients out there that are feeling vulnerable and want to get their documents signed sooner rather than later. This one particular client I'm going to do virtually, even though I think it's probably completely reasonable to supervise the will execution via Skype. I still told the client that I thought we needed to re-execute when everything was going back to normal.
So I'm functioning very differently than I was before, because I had never used Zoom. Even when the Bar Association set it up a year ago, I would always call in and not choose the video choice. So for our practice, for our clients that were scheduled to come into the office, we're calling and indicating that we can either move it out to when we're past New York on pause, or do meetings by video conference through Skype or through phone conferences. And depending on the age of the client, their comfort level with it, some people would prefer to just talk on the phone. Other people are good with video conferencing. And then there's the class of individuals that just say, we're going to wait. We want to meet in person, and we'll push it off until that point in time. From a document execution standpoint, I am going to be in the camp of doing things that I'm not 100% comfortable that I'm doing it right, but I'm making a judgment call and I'm going to stick with it and hope that people come out on the other side and can re-execute. In the last, now it's been about a week, we've received a number of calls from clients that were either prior clients that had done estate planning years ago and now want to update it because they're feeling vulnerable, or folks that, and we all have these clients that, you know, they came in the door, they retained us, but when it comes to actually making the hard decisions that they have to make for us to put their planning over the finish line, they just were delayed for whatever the reasons are. We're all delayed, all of us, in different facets of our lives at different points in time. But lots of folks are self-identifying as being vulnerable, and many of them are. And so it's a function of trying to figure out, can we supervise in the way Jill's just talking about? Can I watch something happen where 3 people are in the room and I feel comfortable that I supervised it as an attorney, even though I didn't sign my name on a particular document? But because of the feelings of vulnerability, the majority of these individuals don't have 2 other people that are going to come in and be in a room with them. And even if they did, they're afraid to have them come in and be in a room with them. And so more frequently, what I am anticipating is that I'm going to be doing something like this, where myself and maybe Debbie are watching Jill or Trish sign their will, sign their power of attorney, sign their healthcare proxy. And I'm going to modify the language in those documents that it identifies how we witnessed them occurring. And again, same point that Jill made before, we're going to have to re-execute them, assuming we can after the fact. And if we can't, then we're going to beg for forgiveness from whatever the oversight body is. We're not in a position where we can ask for permission at this point. We're trying it, but as Jill said before, the legislature is otherwise occupied, and the governor issues executive orders every several days. And this is an issue that we know has been raised, witnessing that is, but it's not been addressed. And again, whether it's because the right language hasn't been set forth yet, or because there's bigger fish to fry, right? If you guys watched the news this morning, there's a pop-up hospital being set up in Central Park. It's an unbelievable state of affairs in New York State right now. So while it's urgent for us, and urgent for a lot of our clients, that level of urgency, I think is somewhat swallowed up by the medical urgencies that the legislature and the executive is trying to deal with right now. So again, we got to make judgment calls and do the best that we can. We're not making suggestions that any practitioner should do what we're doing. The suggestions we're making is that our practitioners have to use their best judgment, make a decision, and figure out how to defend that decision. And hope your clients come out on the other end and can come visit you in your office. They'll be glad to see you. You'll be glad to see them, and have them re-execute whatever they're signing remotely.
So do you have any creative ideas for executing estate planning documents for the clients who do not have Skype, Zoom, FaceTime, some kind of video conferencing ability?
I think if they have an ability to have, if to the point Jill made earlier, if your financial institution is still open and they'll have you in, you can write a letter that explains exactly how things are supposed to be signed, and you could get on the phone with them if they have.
I've actually done that in situations where the clients were someplace else and wanted to get their documents signed. I've actually done that, so it's doable if they've got a place to go.
We have colleagues in other parts of the state that are doing like drive-through executions, and that word sounds bad, right? When we talk about it, a drive-through execution. But they're doing drive-through
execution, meaning signing documents, not
right.
execution.
But where they're standing, you know, a socially acceptable way apart from one another outside in a parking lot where you're not coming into an office, you're not touching door handles, you're using your own pens or you're using gloves, and you're watching from a distance. If folks are comfortable enough to go out and do that, that's certainly a way that they could do it. Now, practices are all taking different positions about whether or not they're essential, and if they are, how many people do they have in their office, or people may just be operating with a single person in their office in order to try to maintain an exemption from the stay-at-home orders. So it's challenging depending upon what position you're taking and how you're enforcing it. And frankly, despite the position you're taking, how responsible you want to be as an attorney, as a practitioner, as an employer, as it relates to the health and safety of yourself, your staff, your families, all the people that you do come into contact with every day. But we do have a colleague on Long Island who's doing drive-through will signings and document signings. And if that works for her clients and they're comfortable with it, she's meeting the formalities. It's just not at instead of being at a conference room table, it's on the hood of a car or in some other sort of unique place.
I think that's really the bottom line, is that, you know, you got to do the best you can under the circumstances. That's all we can do.
So have any of you thought about transitioning from wills as a primary tool to the revocable trust? I know that many times I explain to clients that upstate, our courts are so efficient and great and easy to work with that we don't need to deal with a revocable trust unless there's assets outside of the state. So many times I've told people, no, we don't need the revocable trust. But now, are either of you thinking that maybe it's time to start transitioning to revocable trusts instead of wills?
Is that simply because of the document signing requirement for it?
Well, now it would be, you can do the notary
right
by Skype, but by Zoom or whatever, but you can't really, there's nothing that tells us what we want to do for signing a will works. So do we go to revocable trusts because we know that we can notarize over the internet?
So my gut to that is, well, that's fine, but what are the assets that the person has? And what's the realistic likelihood that they're actually going to be able to have their assets ultimately retitled in the first place? Because that is a hurdle to having that be effective.
Right now, you can't even record a deed. I agree. I would say if you have a revocable trust already, then that makes it that much easier to update and change a document if you want to make some changes. But even with a revocable trust, everybody always does a pour over will. So I think it doesn't really get away from having to do a will if you're really being a prudent practitioner, as we all are.
So Deb, when the courts reopen,
are you glad you joined this call, Deb?
How long do you, at least in your court, anticipate it taking for that backlog to clear?
That's really hard to say. We're going to try to process as much as we can on obviously the emergency and the essential matters. As far as the rest of it goes, we'll just have to work as hard as we can to get it done. I mean, the closings and the inventories and all that are kind of taking a back seat because they're not that important. It depends how much we can get through and how much is being filed. I mean, the filings have gone down substantially, but probably because there was guidance out there saying you can't file anything on NICEF, although that's changed a little bit. And everybody was getting used to their new work situation. So, the work isn't coming in as fast and furious as it usually does. One issue that we have going forward is getting our mail. So that's where all the original death certificates and the original wills are. So we don't know yet what our ability is going to be during this time to go in and collect that information. So what we're suggesting for people that are e-filing is as long as there's an attorney certification that says that they've compared the e-file document to the original document, then in that case, we can process and give temporary letters without putting our eyes on the original will. We'll have to just make do. But the e-filing rules state that you have to file the original will and the death certificate within a short period of time. And so right now, a lot of that stuff is in our office. And we did have access to it this morning, and we will have access to it tomorrow, but we don't know what it's going to look like going forward. That hasn't been determined yet. So, we'll get it done as fast as we can, but we really encourage people that if there's an emergency in Albany County that we can help with, let us know. Most people have my email address, but if you call, they can also email the Albany Surrogate email. I can give it to people right now if they want it, but this is a statewide, but it's Albany Surrogate Court at nycourts.gov. So all emergencies should kind of be directed there. And I'm checking it, Judge Pettit's checking it, and our Deputy Chief Clerk is checking it. So we're on it. So if we see something in there and you really need help, let us know.
Deb, can I ask a question?
Oh, I'm sorry. I just to follow up on the email address. A few days ago, last week, I lost track of time, but one of the days, some information was passed on to me, contact information, email, and phone number for all the county surrogates courts, at least downstate.
In the boroughs.
So, right, that was in the 5 boroughs. I posted that on the listserv, on the Trust and Estates listserv. So there's contact information there and some other information about having access to the courts if you need it. Sorry, Tara.
No, that's okay. We did the same thing. Jill was kind enough to pass that along. And so it's been posted on both Elder Law and Trust and Estates to the extent there's people that watch this that don't subscribe to both sections.
Right, there's contact information there.
Great.
Deb, the question I have for you is, do you have a sense from the administrative judges when the comment of emergency comes up, like what's considered an emergency? And I understand the guardianship, I understand the adoptions, but as you can imagine, a number of people believe the fact that the bottom is falling out of the stock market is an emergency.
Yes. We have issued temporary letters already for that reason.
Just for that purpose. Okay, thank you.
That's good. The other question, not to put you on the spot, Deb, but if there was a petition that was pending, where you had everything, death certificate, will, everything's on consent, is the court, your court at least, issuing permanent letters in those situations, or is that all on hold as well?
We can issue letters on those if they're processed. We might need a reminder because if it was processed right before we left and letters weren't issued, it could just be that it didn't hit somebody's desk. So a reminder would be helpful.
Okay, great. Thank you.
Well, thank you all. I think this has been a really great discussion. It will be posted to the Bar Association's communities, and the members of both the Elder Law and Special Needs section and the Trust and Estate section will have the opportunity to view the discussion, the video, at no cost, no additional cost. We did not set this discussion up as something for which you could get CLE. And I apologize, I should have said that in the beginning, but if you've watched our video, please know we hope you learned a lot, or we opened your eyes as to the way some of us are handling matters during pause, but you won't be able to get CLE credit for it. So one of the things that we think you should do potentially is don't miss the marketing opportunity. Reach out to the clients and let them realize that you're still working, maybe just from home, or that you're able to do things online, and you can still have that meeting that you scheduled, but you're going to do it by video conference instead. As Tara mentioned earlier in our conversation, nothing is really guaranteed with respect to will executions, and we all just need to use our best judgment when we're meeting with clients and making sure that the documents are executed. Taking into consideration that in all likelihood, it would be best practice to make sure those documents, to the extent you can, are re-executed when pause is over and we're all able to meet with our clients in person again. Any final comments, ladies?
Thank you.
We
Thank
went
you.
way over
Stay
our
safe.
30 minutes, but I hope that everyone enjoyed the discussion. So thanks so much.
Thank you.
Take care.